Good day everyone. I'm Carlo B. Espiritu from BSC 3-2, and for today, I'm going to discuss the roles of parties and their counsel on a dispute resolution process. But before we tackle all these matters, let's have a look to our contents of our discussion. First is the objective, definition of terms, the role of the counsel, other matters shall do, the mediator do, conduct of mediation, and lastly, the summary. For our objectives, at the end of the discussion, the student should: number 1, to learn what are the roles of each party in dispute resolution and crisis management, and number 2, to distinguish the responsibility of the counsel of each party in a dispute resolution and crisis management. Now, let us proceed to our definition of terms. Number 1 is party. A person or people forming one side in agreement or dispute. Came from the Latin word partere, which means to divide into parts. An Old French party, Middle English party, which means denoting a body of people united in opposition to others. A counsel, an individual or a lawyer appointed to advise and represent in a legal matters an individual or client or a corporate, especially in a public body. A lawyer engaged in the trial or management of a case in a court. So, for the difference of the party and the counsel is a part of the party, and the party is a whole group or an organization, where the counsel is the specific individual who is skilled and a practitioner of his or her profession. The party is a whole, while the counsel is a part of it. Next is mediation. It is the settlement of dispute between parties by the action of an intermediary or a neutral party. The intervention of a third person or mediator into a dispute to assist the parties in negotiating jointly acceptable resolution of issues in a conflict. It is a process wherein the parties meet with mutually selected, impartial, and neutral person or a third party who assists them in the negotiation of their differences. So, in the mediation, there is a third party person or a neutral person that lies between the two disputing parties. This mediator or he or she serves as the referee or a middle person in a dispute resolution process to avoid further disputes between the two parties. Dispute and dispute resolution. Dispute is an argument or disagreement, especially an official one between, for example, workers and employers or two countries with a common border. On the other hand, dispute resolution is the process of resolving a dispute or conflict between different parties. So basically, the dispute is the problem that need to be addressed or the dilemma that need to have a solution, and the dispute resolution is the process to address the problem. It is the way to formulate a solution for that specific dispute or the problem. I have one question. Tell me if a party can designate or provide their own counsel in a dispute resolution process, or the government will provide one to show the equality for the both parties. A party can provide or designate their own counsel or lawyer in a dispute resolution process, provided that there's a waiver written by the party who waiving it for their preferred counsel, and take note that this waiver can be rescinded in any time. In simple terms, a party can provide their own counsel, otherwise it is provided by the ADR Act or Alternative Dispute Resolution Act, and a waiver is being provided by the party who avail to have their own counsel, and it can be cancelled at any time. Now, let us proceed to the roles of the counsel in dispute resolution process. The utmost responsibility of the counsel on dispute resolution process is the lawyer of each party shall collaborate with each other and view their role as the mediator between their own party or clients. They should collaborate together for the common good of their clients and resolve their dispute and mutual advantages. They need to collaborate to make solution for the existing dispute since at the first place, the responsibility of each counsel is to fix the problem and also to restore the relationship of each party. Each counsel need to help with each other not just for the sake of their handled case, their own profit or whatsoever. They need to help with each other because of their clients since these clients is the topmost priority in dispute resolution process. The lawyer shall persuade his/her client to be cooperative and participate actively in discussing the problem to formulate a concrete agreement and solution for the dispute. The lawyer need to convince his/her client to be cooperative and participative because if the client is not cooperating on the mediation process, how are the lawyers and even the mediator formulate solution and how the dispute will address properly? Cooperation and participation on the part of the client is essential, especially on the part that the lawyer and the mediator will gather pertinent facts about the existing issue. The lawyer must aid his/her client in understanding the importance of the mediation process, its benefits, as well as its responsibility of the client on full comprehension to be able for the process to put in success and resolve the dispute. The lawyer must invoke to his/her client the significance of the mediation process since the client will be the beneficiary of the whole process if he or she fully understands its importance and the effort of his/her client as well as his or hers will not go in vain because the goal of the whole process is to resolve the situation. For effective participation in mediation, the lawyer must discuss to his/her client the following. The mediation process is essential in negotiating between two parties under dispute, together with the respective counsel or lawyer, that facilitated by a mediator. Tackling their differences, advantage, and benefits from litigation, the client's role and responsibility is also crucial in success of the process, together with the role of their counsel or lawyer. Into this, the counsel or lawyer has crucial responsibility together with the mediator. He or she needs to instill to his or her client the benefits of possible outcome of this process into his or her client if he or she will participate in the mediation process. The significant content of mediation are followed. The substantial information and issues regarding on the dispute together with the interests and needs of each clients in terms of their importance. Because this information is the origin of the dispute, this information is crucial since this is the one who will be talked about in the mediation process. The pertinent facts that align on the existing issue as well as the interests and needs of each clients, like if this existing issue is badly needed to address and the client is showing unenthusiastic in pursuing the process to address the case. The next is the careful examination of the claims of each client in regards to the issue and dwelling on its underlying conditions such as interest, fear, needs, and concern. The significance of this is to distinguish if all the claims of each party is relevant to the case and on the other hand for the underlying conditions if other irrelevant interests, threats, and other matters are present. Next, the collecting of pertinent facts and information from the other party to be exchanged and vice versa for crucial decision making. Collecting pertinent facts and information are also important because from those collected facts and information, the decision of the mediator will be made. The decision of the mediator and the results of the process itself is solely based on the gathered facts and information. This information are subject for exchange to the both parties to create solutions on their part through the help of their mediator, especially of their counsel. Next are the availability of other alternative ways on resolving the dispute and to be open for other possibilities and the best, worst, and other alternatives to a non-negotiable settlement. First is the availability of other alternative ways on resolving dispute. For this, it can be monetary compensation, affidavits notarized by a lawyer for amicable settlement, and other ways that depends on the agreement of the both parties. And for the best, worst, and non-negotiable settlement, it falls on the extensive mediation process if the both parties cannot agree upon on the existing agreement. In this, it can be bring to the court and the judge will be the third party if failed to resolve in lower branches and thorough hearing is needed. Now, let us proceed to other matters which the counsel shall do to assist mediation. To assist in the mediation, the lawyers shall give support to the mediator in order for his or her client to fully understand the rules and processes of the mediation. Because the lawyer has the knowledge and skills in pertains to the legal matters, that is why he or she is responsible to make his or her client comprehend the rules of the process as well as its possible circumstances. Next, shall instill to his or her client the significance of speaking for him or herself and taking full accountability and responsibility in taking decision during the negotiation within the mediation process. So for this, he or she is required to instill the importance of speaking to his or her client because the whole mediation process is for the sake of the client and not for the counsel. And he or she is accountable for decision making on negotiations since he or she is the one who is skilled and knowledgeable in that matter. That is why his or her client is seeking help from him or her. Next, may take a break time or recess to be able for him or her to give piece of advice or suggestions to his or her client in private if she sees his or her client ineffective on bargaining during the mediation process. Like what I've said a while ago, the counsel or lawyer is the one who is skilled and knowledgeable to this matter. So, as to his responsibility, he or she can take breaks or recess on the mediation process if he or she thinks that his client is not effective on bargaining and negotiations, and to advise his or her client some ways to do on bargaining effectively and efficiently. And then, the lawyer shall give assistance to his or her client and the mediator put into writings all the settlement agreement that both parties have entered and do. The lawyer must take his settlement agreement in obedience with the law, values, morals, good custom, and public order or public policy. All of the agreement happened on the mediation process must be taken care by the mediator through the aid of the counsel or the lawyer. All of the writings, agreement for settlement, and whatsoever must be aided by the counsel, of course, in obedience to the values, morals, good custom, and public order and policy to make the product of the whole process in good result. And now, let us proceed on the conduct of mediation. Articles to be considered in the conduct of mediation. First, the mediator shall not exaggerate his or her claims and make dishonest assertion on the dispute resolution process, its costs and benefits, its result or the abilities, background and qualification of the mediator and the whole dispute resolution process. As the mediator, Do not be so extravagant and make lies on the whole process as well as to its benefits and result, especially the background of the mediator. You are here to mediate two disputing parties and not to brag your qualifications for the both of them. Next, the mediator shall satisfy both of the parties in pertains to the result of the mediation process, but do not have the power to impose settlement on both parties. In here, the mediator shall help each parties impartially and attain the result without aggravating other party, and as the mediator, you need to mediate and formulate solution and not to dictate what they are going to do in their dispute process. Next, each party must personally attend on the mediation process and can be assisted by a lawyer. If a party is not available, they must send a representative that has full authority to negotiate and settle the dispute. To attain the expected result of the mediation, both parties required to attend personally the mediation process, and if they are not available, they can send someone or relatives or friends or any representative who is capable in negotiation and settle the dispute. The mediation process in general shall consist the following stages. First, the mediator's opening statement, which the mediator introduces everyone and explains the goal of the process. Second is the disputant's opening, where both parties give chance to utter their claims based on their experience in a relation with the dispute without the interruption of the other party. Next, joint discussion. In this, the mediator will talk to the both parties and try to address the issue. Then, private caucuses, where both parties will meet with the mediator separately and talk about the issue to address it properly, and through the strengths and weaknesses of each party, the mediator will try to create ideas for the settlement, and it is considered the gut of the mediation. Followed by the joint negotiation. In this step, the mediator and the both parties will talk about possible ways and agreement to settle the dispute together. Lastly, the closure. It is the end of the mediation process, and arbitration will follow if no agreement is formed. The mediation process shall be commenced in private. Audience other than two parties, their counsel, representative, and the mediator may attend, but only when consented by both parties. The mediation shall be closed by the execution of settlement agreement by the parties, by the withdrawal of any party from the mediation, and by the written declaration of the mediator at any further effort at mediation would not be helpful. And that's all for my discussion, and these are my references and the quotation from Abraham Lincoln quoted, "The best way to predict your future is to create it." And that's all. Thank you for listening.